All rise.
All right, be seated. Mr. Evans, let me say that you cannot testify to anything that would be considered client privilege, client attorney privilege.
Absolutely.
You understand that?
I do.
Okay.
And I want to say for the record, at no time during my examination have I testified to anything.
Sometimes the way the questions are couched might raise concerns, okay? So listen very carefully, because you can't disclose communications between you and Mr. Austin.
Absolutely.
Okay.
And wouldn't.
Now, the state had asked you about a quote that Shane Austin presented in the proffer session. And it was the one where Shane said that Zach claimed to have Holly Bobo chained up out back and called Shane to fuck her. Isn't it true that that statement was made by Zach Adams in a bar to unknown people?
I'm going to object to hearsay, speculation. He can't know when it was made.
No.
I mean, if his client made certain representations about when it was
That
made.
would violate privilege.
I'm sorry. Isn't it accurate that that's something that Shane Austin said in the proffer? That he heard Zach Adams say in a bar to unknown people, he had Holly chained up at back and called Shane to fuck her.
According to what's said in the proffer in the IR, that's what's written there.
And according to the IR, when Shane said that no body, no crime, at that time, that was not something that Shane Austin took seriously. And that's what he communicated in the proffer to the agents, isn't it?
I'd have to look back and see what the proffer or the IR says. Again, those statements weren't made to me; they were made to agents with the TBI.
It's in the last paragraph. On the first page.
What I've got is Agent Russ Winkler's IR here that says, according to Shane Austin, the topic of Holly Bobo came up here. Zach Adams answered twice. In regards to disposing of bodies, say you have to gut them so that they won't flood. Shane Austin says that he also heard Zach Adams say, no body, no crime, in connection with the Holly Bobo investigation. Zach Adams says things like this to a lot of different people. Be sure that we've heard the same comments from Mr. Adams, or from Zach Adams. That's what Mr. Winkler noted.
Okay. And then towards the end of the IR, doesn't it also note that Shane Austin said he never believed that Zach Adams had actually killed Holly Bobo?
Agent Winkler notes on the second page, according to Shane Austin, he should have told this information earlier, but he was a little apprehensive. He grew up with Zach and went to the same church with him. He just never believed that Zach was saying, what Zach was saying about killing Holly Bobo, about killing Holly was true. That's according to Agent Winkler.
Okay. And so the items that were written on the piece of paper and provided to the TBI, these are items that Shane Austin told the TBI he had heard Zach say. Is that correct? I mean, according to the report, these are things that he wrote down that he had heard Zach say.
Either he remembers it or doesn't remember it.
Sustained. Do you have a question?
Yes, Your Honor. And in fact, Shane Austin, during the proffer session, told the TBI that he had been with Zach Adams on the morning that Holly had disappeared. Isn't that accurate?
I'll have to look at the that's according to Agent Winkler's notes or his report. That's what was said.
And also he told the agent that he had gone into Parsons with Zach Adams and Dylan Adams to purchase Xanax bars during the proffer.
Again, according to Agent Winkler's notes, that's what was said.
And Austin denied that he had, in the proffer, that he had ever
Object, but if she wants to ask.
Did Shane Austin disclose in the proffer that he had ever disposed of any evidence on behalf of Zach Adams?
Again, according to Agent Winkler's report, it says Shane Austin said that he did not help dispose of Holly Bobo's body. That he has not ever gotten rid of any evidence, and that he has never been asked to do either.
Okay. And did Shane Austin, during the proffer, deny to the TBI that Shane had anything to do with Holly's disappearance?
I'm sorry, I didn't understand the question.
During the proffer, did Shane Austin deny that he had anything to do with Holly's disappearance.
Again, I'm referring to the report. Agent Winkler's report. I mean, Agent Winkler's report notes him as saying that he did not help dispose of Holly Bobo's body, and that he has not ever gotten rid of the evidence that he has never been asked to do.
And does it mention that he denied having any personal knowledge of what happened to Holly Bobo?
Yeah, Agent Winkler notes on the first page, Shane Austin said that relevant to Holly Bobo investigation, he does not have any direct knowledge of anything to do with her disappearance or death. He claims that everything he knows is based on what Zach Adams told him.
There's no further questions.
Mr. Evans, on March the 8th, 2014, 2 days after the proffer, you emailed Beth Boswell and said, "It is the position of my client that he was truthful, candid, forthcoming, and cooperative with the government in this matter." Correct?
Yes, that's what the email says, that's what I said.
And the matter that you're referring to is the information he gave in the proffer. Correct?
I was noting my client's position regarding the information in the proffer.
So that's yes.
I'm not sure if it's a yes, I'm not sure if it's a question, but I'm wondering.
You said in this matter, that your client was truthful in this matter. You're referring to the proffer, correct?
I didn't say my client was truthful, I said it's my client's position.
I'm talking about in this matter.
Yes,
You're
that would be the
referring to
proffer.
the proffer. It's not a difficult question, Mr. Evans. You're a smart man.
I appreciate
You're referring to the proffer, were you not?
Yes.
There you go. Not that hard. In addition to the information given in the proffer, you are referring to 1 through 5 handwritten notes by Shane Austin, weren't you?
I was referring to exactly what it says, ma'am.
Right. And in fact, you thought your client was so truthful, forthcoming, cooperative, that's what you said, that you filed a civil court action to enforce the immunity agreement for Shane Austin, right?
Ma'am, I was his attorney.
I'm sorry, it's a real easy question. Yes, you filed a civil action, or no, I didn't file a civil action.
I did file a civil
There you go.
action. My thoughts regarding anything related to my client are privileged.
You filed a civil action, maybe privileged, but you put in here that it's your position, your client's position, that he was truthful, right?
Yes, I
But
understand.
you wouldn't have filed a civil action with no legal basis, in your opinion, would you? Because that would be unethical.
No, I would never
Right.
file anything that was not based in fact law.
And so because you filed a civil action confirming, affirming Shane's veracity, that means you believed him with respect to Zach Adams and what he heard Zach Adams say. Because to do otherwise would have been you filing a civil action with no legal basis.
I can't answer that question.
Nothing.
Okay. Done.
Yes, Your Honor.
Step in. Next witness.
Do you have the witnesses, Your Honor?
Okay. You want to be heard?
Yes, Your Honor.
I'm assuming the state does not wish to call witnesses.
We do not.
All right.
And so I'd like to see exhibit, was it 1, again, the proffer, it might be a proffer. So, Your Honor, The state's trying to make a point in this case that because Shane Austin came in, did a proffer, and said those things, that then that makes Shane Austin's position inconsistent with the trial theory in this case. And the state is clearly misrepresenting what happened at the proffer. What happened at the proffer was that Shane Austin went in and said, I heard Zach Adams say these things. He put it on a piece of paper. I heard Zach Adams say these things. He wrote these things on the paper. At no time did Shane Austin go into the proffer session and say, I know that Zach Adams killed Holly Bobo, or that anything of that nature. What he said is, look, I have no personal knowledge. I've heard Zach say these things. And, Your Honor, that is not going to be inconsistent with a defense in this matter. In this matter, it's not inconsistent to say that Zach Adams may have had and said some crazy things. What the state is wanting everybody to overlook is the fact that Shane Austin was with Zach Adams that morning. That Shane Austin did not believe that Zach was telling the truth. That Zach Adams had said those things to multiple people, Your Honor. And that does not make a conflict in this matter. First of all, and I will just point to the law. You know, the state cites no law in this case saying that Mr. Evans cannot represent Zach Adams in this case. But in this case, and the law on attorney conflicts has changed in 2011. The whole law on professional conduct was wiped out, and there's no longer canons. Now it's the rules of professional conduct that are in play, and there's no longer an appearance of impropriety. That was removed completely. It's a true conflict in the case, and in this case, there's two types of conflict, and this is under the rules of professional conduct. There is either an actual conflict between two present clients. You can't represent one side and the other side in a divorce. You can't represent both parties in a divorce. And that's never going to happen. There's never going to be that kind of conflict between Zach Adams and Shane Austin because Shane Austin is deceased and he can never be charged with a crime. The second type of conflict in this case or in the statute, in the rules, is that there is a conflict, you representing a current client, and because of a representation of a former client, somebody you've represented in the past, because of something you know about that former client, it's going to restrict you on what you can do for the current client. And that is not an issue here either, because there's no tool in the attorney tool belt that Mr. Evans has that he cannot use for Zach Adams. Because the harm in this case, because it was a criminal case in this matter, the harm in this case would be that Shane Austin would be charged with a crime, convicted of a crime. And that is never going to happen. So in this case, if it would be possible, and there would still be no conflict in this case, for for Luke Evans to represent Zach Adams and go in and completely blame the whole thing on Shane Austin. He could go in there and said Shane did it and come up with a complete story about what happened. That would still not be a conflict with the past client, because regardless of what they would ever say, and this is just hypothetical, it could never result in charges against Shane Austin. And that's specifically what is in the law. I mean, that's what the law says. In addition, the theories are not inconsistent. The fact that Zach Adams may have said some crazy stuff in a bar does not make it more or less likely that Shane Austin would be charged in this crime. And it is not an inconsistent theory with what the trial theory would be. And so because there is no actual conflict in this case, then the court could look as to whether there's a potential conflict. Well, there's no potential conflict that could possibly arise in this case either, because Shane Austin can never potentially be charged with a crime in the future. It could not happen. And Luke Evans was representing him in a criminal matter. It's not like he was representing his estate or doing a will for him. He was representing him in a criminal interest. And that criminal interest has died when Shane Austin passed away. Then the law is also clear that the court used the wrong standard when determining whether or not to remove Luke Evans, because the court used the standard that was the appearance of impropriety that would erode people's faith in the judicial system. Well, there are 4 other attorneys in this case that could have possible conflicts. One, Mr. Maddox, and this is in the discovery, came in and did a proffer session with another witness who came in and said things about Zach Adams and Jason Autry. And he did that in 2014. In May of 2014, he met with TBI agents in this case. TBI agents that are here did a proffer session, and they did a report on that. Paul Bruno, before engaging to represent Dylan Adams in this case, went to meet with Jason Autry in prison at Riverbend Prison at the request of Jason's mother to discuss possible representation. He met with him. He discussed things with him. But before he came on to represent Matt Maddox, he made sure that there was no conflict. They took appropriate action, discussed it with Jason Autry's attorneys. In this case, Jennifer Nickel was working for Matt Stowe.
I object, Your Honor. I never worked for Matt Stowe.
She was working on this case under the direction of Matt Stowe.
No, sir. Incorrect.
No.
She filed a... She was
Notice
on
of appearance
conference
pro
call.
tem.
Okay, well, she came in and was on conference calls and was working on this case while Matt Stowe was still the district attorney. Matt Stowe filed a notice that he had to get off the case because of a conflict. Jennifer Nichols was allowed to stay on the case. Under the code, usually when one person in a firm has a conflict and a district attorney's office is...
Do you know
considered-
why Matt Stowe got off the case?
No.
It's essentially because he called the TBI a bunch of liars. Miss Nichols did not call them that.
Well, it could be the appearance of impropriety, Your Honor, because he had a conflict and he got off and she stayed on.
Actually, I didn't say that, Your Honor. I got off the case.
Well, she's back on.
I got off the case and was not reappointed until after Matt Stowe was taken off the case.
That's correct. And I did not discuss that with her, but I got a call from her district attorney that said she will no longer be involved in this case, period.
Okay.
Once the conflict was resolved, I signed an order appointing her pro tem.
So she was working with Matt Stowe when Matt had a conflict, and that conflict was not imputed to her to work on the case later, even though it might have been. I mean, oftentimes a conflict is imputed to another attorney. Beth Boswell worked for 2 different agencies. She was the district attorney or assistant district attorney in this case, and was also part-time special assistant United States attorney in this case. And she had 2 different roles. I mean, she
Why
represented
don't we
2 separate-
confine this to Zach Adams and Luke Evans?
Okay. So, Your Honor,
That's the conflict we're here to discuss.
yes, there's no conflict between them. And to be more clear as to what the law says, there have been other cases in the past where they looked at conflicts, and the courts have held that a conflict that is remote, that is, let me find a law here. There's a case called Burns. It's Burns v. State. And in that case, it was a death penalty case, and the post-conviction defender's office was appointed to represent Mr. Burns. At some point, the district attorney's office decided that they no longer wanted the post-conviction defender's office representing Mr. Burns. They filed a motion to have him recused, and the trial judge granted it, based on the fact that somebody in the post-conviction defender's office was a relative of the victim who had died in the case. And the Court of Criminal Appeals said, no, that was not enough of a reason, that there was not an actual conflict in that case. They evaluated that case based on the appearance of impropriety. And based on the appearance of impropriety, and then they went through other rationale as to what could be taken to assure that there wouldn't be a conflict, such as bringing the client into court, having the client say on the record that he waived the conflict, he understood it, and all of that could be done to ensure that the public would remain confident with the judicial system. But since the law was reworked, they've taken out that appearance of impropriety under the law. That now there's only a very, very narrow appearance of impropriety that is left in a comment number 9 to Rule 1.10 of the Rules of Professional Conduct. That cites a case that was a Tennessee Supreme Court in which an attorney was representing a couple in a boundary dispute. He left his firm and went to work for the firm that was representing the opposite side in the boundary dispute. The dispute was still going on. There were two current clients, and the Supreme Court found that the appearance of impropriety in that case was so strong, even if he promised not to tell any secrets, it still looked so bad that it eroded the public's faith in the system. But in that case, there were two current clients that were still in the same disputed matter with each other, and one of the clients had something to actually lose. I mean, one of the people was going to win at the expense of the other client. And there's a comment that still allows for an exception for appearance of impropriety if it's that narrow of a ruling. But in this case, Your Honor, the Board of Professional Responsibility found there is no conflict here. There's no actual conflict, and there cannot ever be.
What if they didn't have all the information?
Mr. Evans testified that he told them that he ran scenarios by, and one was, what if Mr. Adams actually came in and what if Shane Austin had actually implicated Zach Adams in the case, had said he did it, which that's not what we have here. Shane Austin said, I heard Zach say things, I never believed him, is what is in the record. And Mr. Austin ran a worse scenario than that by the Board of Professional Responsibility. And they said no conflict because Shane Austin can never be charged with a crime. And so I argue, and the other problem with this is the state has not filed any motion in writing. There's no motion, there was no oral motion as to what their objections were. There was nothing in writing.
They filed a response.
Well, I know, but they didn't file a motion. And they filed, I thought the response was to the recusal.
No, the response, all of it was in the same document.
Well, it's a response to the recusal, not to the court, not...
No, they covered all of it.
Okay. So...
I read it this morning.
In this matter, Your Honor, there's not a conflict. There can never be an actual conflict. There will never be a potential conflict. And so, based on that, it was improper for the court to remove Mr. Evans. The court used the wrong standard to remove Mr. Evans, and therefore we ask that the court set aside that order and allow Mr. Evans back on the case.
Here from the state. Just get that to her.
May I proceed?
You may.
Trying to start at the end and go backwards.
You can go any way you want to go.
I'm dumbfounded that Ms. Thompson would say, there is not a conflict, there can never be a conflict, there, under any stretch, because I'm looking at her handwritten waiver where she got Zach Adams to sign saying the exact opposite. The exact opposite. So for her to stand before the court now and tell you that under no conceivable scenario could there ever be a conflict leads me to believe that they, the defense, really are trying to set up a situation where, in the event of a conviction, in the event that Zach Adams is sentenced to death, that they have a built-in successful post-conviction relief petition and or federal habeas. Because why else would you say that? Why else would you sit here in court and say that we have consistent defenses when they are so clearly inconsistent? If you're not trying to set this court up. And as far as bringing Mr. Maddox into it, Mr. Maddox had a proffer with somebody that wasn't a suspect. And he's free to stand up and help me out.
I'm not interested in
it's not.
Maddox. I'm not interested in you, whoever else she said had it. We're here, as I said earlier, concerning defendant Zach Adams and Luke Evans. Is there a conflict is what the subject is.
Trying to stay on course, Your Honor, it's clear that there is. They cannot know. They cannot know how this trial is going to play out. And there are so many scenarios where the exact things that they are saying do not present a conflict, simply do. We have TBI agents who were witnesses to things said by Shane. There have been statements made by Mr. Scholl on the record today about representations he was made to Your Honor about his client situation. I'm not going to get into that now. But there is a conflict. If Your Honor wants us to spell out in more detail the situation of other defendants, we will. It was my hope to avoid doing that at this point in time. But the representations made by Shane Austin of things he overheard or things that Zach Adams told him regarding the murder, rape, kidnapping of Holly Bobo. We have other proof confirming those statements. We absolutely put on the record what was said before, and that's what we're asking that Mr. Evans be, that you affirm the disqualification of Mr. Evans from this case and allow us to proceed with attorneys that don't have that conflict.
Right, thank you.
I would like to address the one issue about the waiver of conflict, Your Honor. If you do a waiver, then they say, and especially a waiver of something potential, you just say, there might be something in the future, and I waive it. That certainly is not indicative at all that I was trying to be sneaky or tricky. A waiver just says whatever's there, I give it up. And as an officer of the court, I am absolutely not trying to do any kind of tricky things. I'm trying to take this man to a trial and do the very best job I can for him. And I believe that at this point, having a third attorney is absolutely essential. The state has 4. And Mr. Evans was an excellent choice because he knew facts about the case and he was ready to get to work on it.
Let me ask you something concerning ex parte motions under Rule 13. I have met with all attorneys in this case at various locations for ex parte motions concerning services. I've met with you or Mr. Simmons in 4 different counties and in the city of Nashville to
Yes.
accommodate. Do you recall a conversation where you mentioned to the court that you might ask for an additional attorney, essentially that the state had 4 and you felt like it. You felt like that it merited.
Yes, sir.
You recall my response, if that's in violation of court rule, it can't be done, and you said I might want to build a record on that sometime.
Yes, Your Honor.
But yet you proceeded with an ex parte motion as opposed to a motion for extension of Rule 13 to add a 3rd attorney.
I guess all funding motions under Rule 13 are ex parte, as I understand them.
The appointment of attorney might not necessarily be.
Well, the funds to pay for an attorney would be, if we're...
But the state had no opportunity to raise the conflict issue because of the way it was presented, correct?
That's correct, Your
All right.
Honor.
Take about a 5-minute recess and then we'll have a ruling.
All rise. Let's get back in our seats, please. All rise.
Mr. Simmons is front of us.
He's running back. I know that people run to the restroom. I didn't know they ran back. All right, be seated. Concerning the court's ruling, in retrospect, which they say hindsight is 20/20, the appointment of Mr. Evans should never have taken place in an ex parte motion. Those are for services and things like that to provide indigent defendant adequate representation, such as, and I'm not referring to anything in this case, I'm just saying in general, mitigation specialists, investigators, there's any number of things. It should have occurred to me that I've never seen an attorney put on board through an ex parte motion. The first time I realized that that was the improper vehicle was when I got the telephone conversation of less than 2 minutes. She said, I have concerns, and it occurred to me at that time they had not been able to express concerns that the court might have been very interested in. That's why this should have been taken up in open court, where they argue that, yes, Rule 13 requires 2 death penalty certified attorneys and does not provide for a 3rd attorney. Mea culpa. I shouldn't have done it that way. But once I realized that what the conflict truly was in this case, I didn't let either side go into any discussion during that telephone conference. And the words that I used were not appearance of impropriety by Miss Aaron, by her notes that were read earlier. It was appearance of conflict. I am absolutely satisfied that there is a conflict in this case and that there is a distinct likelihood of additional conflicts developing throughout this case, and particularly in the sentencing phase, where the rules are different. There might be hearsay. I think Mr. Evans would be placed in an absolute conflict of interest, having received information from his now deceased client that might be in conflict with what Mr. Adams might or might not place evidence concerning. I honestly think that probably there's no one in this courtroom, with the possible exception of Ms. Thompson, that does not see the conflict in this case. It's overwhelming. If we were to use the medical scale of 1 to 10, where they ask you pain, I would say conflict is at 10 on this case. That's how strong it is, and that's how strong the court feels. It's not proper for Mr. Evans to serve on this particular case. The court confirms its earlier disqualification. I will prepare an order consistent with this. Also, I want to say that concerning the court's recusal, under 10B 2.04, the filing of a petition for recusal appeal does not automatically stay the trial court proceeding. However, either the trial court or the appellate court may grant a stay on motion of a party or on the court's own initiative pending the appellate court's determination of appeal. That stay is hereby on the court's own initiative, granted in this case concerning the recusal motion. All right, anything further?
Not from the defendant, Your Honor.
I'm sorry. I would like permission to appeal, interlocutory appeal on the disqualification of Mr.
Denied. You may seek an extraordinary appeal if the Court of Criminal Appeals wishes to grant it. I don't see this as an issue. Yes, sir.
Your Honor, there have been a number of Rule 17 subpoenas, and I would ask if there's anyone here in response to a subpoena with records in the audience.
Amen to that. I don't know how many I've signed, okay? But I would say probably 25 at least. And once again, I've met, I can't think of his name, with your investigator a multitude of times. I've tried everything I can do to try to help the parties expedite this, including scheduling the ex parte motions, meeting your investigator for purposes of issuing subpoenas, the ones that can't be issued by the clerk.
Correct, Your Honor.
But what I'm saying is, I've tried to accommodate so that we can keep a reasonable time scale on this. And as one of the attorneys said at the outset, it might have been her, I gave everybody in this case my cell phone number and said, to avoid any problems whatsoever, scheduling or otherwise, you're free to call that number. Okay?
Yes, Your Honor, if there's anyone in the courtroom that is here in response to the subpoena.
Anybody here that's been served a subpoena to provide certain records?
I did serve an executed to your investigator. There you go.
Okay.
I think we've got them all. Thank you.
All right.
And then, in response to that, Your Honor, reciprocal discovery motion has been filed, and we've never gotten anything, so we sure would like to keep that as we move forward with Mr. Adams, Zach Adams in particular, since he's going to trial in 3 months.
Right. I don't want to do it right now. I want to keep their feet on fire. All right.
Did Your Honor stay the proceedings?
I did not stay.
Okay, I was trying
I
to...
said on the front end I would not stay it. You know, the reason that the trial court doesn't stay proceedings, any case that I have set, somebody can file a motion to recuse 30 days prior to trial, and if it is stayed, your trial date is busted. So I specifically am not staying anything in this case, okay? If I misspoke or misunderstood, I want the parties to understand that.
All rise.
Grab that. Need from the first motion and ruling, I need that transcribed where we can attach that to an order. Okay?
Your Honor, I believe there was another court date that was potentially set in this matter.
Right.
Is that still the case?
March 1.
Judge, may I ask on behalf of Mr. Autry that we do not participate in that report date. We are taking a different route. We are not set to trial in April, and we will have nothing to do with report to the court.
Be excused.
Thank you.
I've excused both defendants from being present today because we weren't taking anything up regarding them.
Can counsel for both defendants be excused on that?
If they wish to, yes.
Thank you, Judge.
And do we want Dylan Adams here on March 1?
We'll have to let you know. We'll let you know more details.
Court's adjourned.
Right.